All right. Let's go to work, James. 2 days in a row I'm making a video. What do you know? I wasn't going to make a video this morning, but I read an article in my Facebook feed posted by Dr. Jordan Peterson. It's a Globe and Mail article regarding proposed changes to the rape laws in Canada, or rather the rape criminal proceedings rules and laws in Canada. Essentially turning Canadian justice system and Canadian courts into a kangaroo court, similar to what they have on college campuses in the United States and probably in Canada as well. I don't know about how sort of proceedings happen on universities in Canada, but I know that Title IX is a big factor in the U.S. proceedings between students when there's complaints of things like sexual misconduct and discrimination and whatnot. But anyway, the proposal is that when people are before the court, or going before the court in cases of rape, the past internet communications, sexually explicit video, or sexual messages, sexually explicit messages would no longer be considered evidentiary or admissible as evidence unless they are first approved by a judge in a closed proceeding. Similar to the way the law currently in Canada, a person's past sexual history cannot be brought into the court proceedings in a rape case unless first approved by a judge in a closed session. So lawyers would have to bring evidence of past sexual history forward to the judge and say, hey, is this relevant? We want to admit this, we think it's relevant to the case, and the judge gets a decision to say yes or no. Well, now, text messages that happened before or after the incident, photos, video, anything regarding conduct between the two persons or of that one person would follow under these same rules. Letters, journals, medical records. So if the defendant happened to have medical records that indicated that the accuser had psychological problems and a history of making false rape claims, that would have to first be approved before it could be admitted as evidence. I tell you, it's insane. And it might not ever be admitted as evidence, and it may be the only defense that the defendant has. And this is just, it boggles the mind. This is what the state of our judicial system is going to become in Canada. That's what happens when you elect a feminist prime minister who fills his cabinet with feminist ministers. So this is there was a quote in the article, and I don't know if it was a direct quote from somebody or if it was a expression of sentiment of prevailing attitude that this proposed legislation would bring forward. And it stated basically that this essentially is brought into effect to hold men accountable. And I'm like, hold men accountable? That's implying that all rapes are committed by men. Though I don't know the laws in Canada, it's perhaps such that women can't be charged with rape in Canada or sexual assault on a man. But I don't know. I ain't no legal scholar. But just think about it from a perspective of any other criminal court proceeding. Imagine that someone is accused of theft, and the only thing they have to admit as evidence or submit as evidence are receipts or text communications discussing details of the sale of property or transfer of property. And then the court says, no. Before you admit that, it's got to go before a secret proceeding with a judge to determine if it's relevant to the case. Now, in a case like that, it probably would be deemed relevant to the case, but judges are fallible. Judges can be corrupt. Judges can have bias. So, in a clear-cut case like that, it would have to be admitted as evidence, right? But just imagine them saying, no, you can't admit it as evidence because it besmirches the character of the accuser. Which is essentially what this whole change to the rape laws in Canada is doing. Basically, we don't want you to besmirch the accuser, so we're going to make it harder for you to admit evidence that would call their character into question. That's essentially what this comes down to. And they cited, some of the people citing reasons in favor of this decision are, well, they cited the John Ghomeshi case, whereby basically he was exonerated. He wasn't even found not guilty. He was completely acquitted because, in part, of correspondence that indicated that this person was a willing participant in the activities of John Ghomeshi and the accuser engaged in. So this change to the legislation is being stated that it was drafted in response to the outcome of the John Ghomeshi case. Basically, they didn't like John Ghomeshi. This woman accused him. They wanted him to go to prison. They wanted him to be found guilty. And the evidence wouldn't support a guilty verdict. So they want to change the laws of evidence so that a case like the one in John Ghomeshi will never happen again. Just ridiculous. And again, if you extrapolate it to other criminal proceedings, other criminal cases or other crimes, you'll see how ridiculous it is. Your Honor, he stole my bike. Well, we have evidence to support that it was a trade for services rendered, mowing the lawn or whatever. We've got receipts, we've got a contract, we want to bring it forward. Nope, sorry, that's not admissible. It has to be reviewed before you can admit it. Before a private proceeding, before a judge. That's just how ridiculous it is. How about this? What if it was a joint custody case? This is a little bit more, I don't know, relevant because it involves accusations between men and women. So a man accuses the co-custodian of their daughter of taking the child on a day outside of the normal arrangement without his consent, or taking the child away for a weekend without his consent. And the mother of the child says, well, no, we've got email correspondence that indicates that he was okay with this, and now he's coming back because I brought her back, an hour late on Sunday. So now he's coming back at me and he wants to get back at me. Imagine then if the family court said, no, you can't admit those emails into evidence because it would besmirch the character of the father in this case, the co-custodian, and we're not going to allow it. It's not just about besmirching character either, right? It's also done in an effort to get more women to come forward in cases of rape. And this is a big problem that they say is at the root of this issue. right? Women aren't coming forward or proceeding with rape allegations because the evidence doesn't sit in strong support of their story, right? So basically what happens is, I guess they cited one police department that said, look, only 1 in 5 of reported rapes ever goes forward to trial. And so 4 out of 5 are either abandoned because there's lack of evidence, or the prosecutors and the police don't see a case. What it comes down to is basically it's a matter of he said, she said, and the court can't weigh in on things like that. There has to be more ample evidence. So they see that there are a low number of convictions in relation to accusations, and they say we need more convictions in relation to accusations. Maybe we should, I don't know, seek to have fewer accusations in the first place. It's I don't know if this is even worth discussing. Because I don't know that you're going to convince people on the other side. For certain people, they just believe that men are the problem, men are at issue. Conduct of women is never to be questioned. Women are simply to be believed and supported, regardless of what the evidence shows. This is the prevailing attitude. Listen and believe, right? Listen and believe. As though women never, ever make false rape accusations. It's an insult to the justice system, and it's it's feminism run amok in the court system, and it essentially turns Canadian law, insofar as this offense is concerned, into the equivalent of the kangaroo court system that they have on college campuses in the United States. Yay, Canada. Pulling into work now. Hopefully I can get a parking spot. Well, thanks for watching. I'll shut this off before I finish parking.